Good evening to one and all present here, and good morning to Professor Bakshi, who's joining us from Utah, and it's 6 a.m. there right now. Um, on behalf of DAKSH, I would like to welcome everyone to this webinar, where we are going to discuss on the paper titled Service Operations for Justice on Time, a data-driven queuing approach. I'd like to welcome all the speakers for this webinar. Without further ado, I would like to hand over the mic to author and presenter of the day, Professor Nitin Bakshi. Sir, handing over to you.
As well. Services being healthcare or education or indeed legal services, right? So this is a setting of legal services where we're providing justice as the service or a decision on a dispute. Invariably, service systems are congested. And that's part of maximizing the performance of such a system. So you run into congestion invariably in service system. So then the mathematical theory or mathematical discipline which studies congested systems is queuing theory. So then for me, being an Indian, it was a long-standing ambition to contribute or an aspiration to contribute to this side, to judicial services. And I started this project in around 2017, where again, DAKSH was instrumental in guiding my initial efforts. So I wanted to acknowledge that. So this is the outcome of many years of effort, because in the end, once you know what you're doing, it doesn't take that much time, but just to figure out what needed to be done and have the data, the requisite data, just took me many years. So without further ado, let me dive into the meat of the subject, but also give a nod to my co-authors, Jeunghyun Kim at Korea University and Ramandeep Randhawa at the University of Southern California, both also business school professors and experts in queuing theory. A little bit more in terms of acknowledgement, people who helped me along. We had conversations with former justices of the Supreme Court, Deepak Gupta and Madan Lokur. And I noticed that Madan or Justice Lokur has helped many such initiatives. So I'm one of those, I suppose. I also got inputs from practicing lawyers at the Supreme Court, Mr. Gaurav Pachnanda and Mr. Sahil Tagotra in particular. And I also spent time at the Supreme Court trying to observe the proceedings just to get a sense for how things are actually done in practice. And the registrar at the time, this must be 2018 or 2019, was Justice Sanjay Parihar. Ever since, he has gone back to the High Court of J&K, which is where he is his home High Court. Last but not the least, once again, from DAKSH, it was Mr. Harish Narasappa and Mr. Surya Prakash who had helped me initially get started on this project. So what was the objective here? Was to use the data, which a number of you have seen on the case status page of the Supreme Court, and downloaded, and try to recreate or replicate the functioning of the Supreme Court. Not exactly, that is an impossible task, but in a coherent and plausible enough manner such that whatever causes congestion in this digital cousin, let's call it cousin, not a twin. So I created a simulation framework using queuing theory. What would drive congestion in this system would hopefully give some insight into what drives congestion in the actual Supreme Court. And once we have that baseline model in place, the idea was that let's study the effectiveness. Let's do counterfactual exercises. What if things were different? What if I added judges? What if I reduced the number of adjournments? These are talked about a lot already. People know these are potential issues. What's the bang for buck? So I know this is going to go in the right direction. If I increase the number of judges, delay will come down. How much? Or if I reduce the number of adjournments, that will be helpful, but it's hard to reduce adjournments. So can I say something beyond that? Those were the initial goals. I will show you towards the end that what we found was something substantially more. But all of these were operational interventions in the sense that they do not attempt to revisit the legal decision-making process, in the sense that whether the judgment is favorable or unfavorable to a particular party, we wanted to remain agnostic to that. By that token, other powerful interventions such as alternative dispute resolution were beyond the scope of our analysis, right? Because then you're tinkering with the outcome of the case potentially, because there's an alternative way of looking at it. And we didn't want to get into it, especially as a first step, right? Maybe going forward, that would be a promising direction. Finally, with Siddarth, Raman, I was just discussing before that, the Supreme Court is congested, no doubt. And then because it's an appeals court, a lot of US appeals courts are also congested. So it's interesting in its own right. But India's biggest problems are perhaps in the lower judiciary, where the data is more spotty, not as clean, not as widely available. So one of the ideas was that, okay, let's understand things in a relatively easy setting, which is the Supreme Court of India, and then hope that some of these frameworks, some of these ideas can potentially guide our hand when we think about lower judiciary, because that's ultimately where bulk of India's problems lie. So with that as the backdrop in terms of objectives, a quick recap of how we viewed the Supreme Court. Of course, you're all experts, so you know about this, but just a quick one. The highest court in our judicial hierarchy. Right now, the sanction strength is 34 justices, but at the time we started the project, the number of justices who were on the active were only 28. So it's around 2017, 2018, that time frame. The jurisdiction is obviously, it spans original cases as well, where a human right case could go directly to the Supreme Court and other types of cases. But about 80 to 90%, almost 90% of the Supreme Court's workload is appeals. The appellate jurisdiction, which is essentially high court decisions being appealed to the Supreme Court. And that's where we focused. Why? Because it's not to suggest that constitutional matters are not important. They're super important. Perhaps the most important thing, perhaps the primary reason the Supreme Court exists is constitutional matters. However, in terms of workload, so queuing theory is looking at, in terms of congestion, is 90% of the workload is appeals. So if we can take care of that and figure out a way to control congestion with respect to appeals, then that frees up time and allows the Supreme Court to devote more of its attention to constitutional matters for that reason. So coming back to how it influenced our research, we focused on mainly appeals. Also, when we tabulated the data, which was for 8 years from 2009 to 2016 that we downloaded, we found about 40,000 new cases per year. Now, if you look at the Supreme Court annual reports, they're talking about 60,000 cases a year. And this Nick Robinson, if you're aware of the researcher, has already highlighted some of the challenges with how the Supreme Court records its data. For instance, if an initial case is filed at the Supreme Court, but it has errors, then those errors are to be cured. But once those errors are cured, the Supreme Court records it as an arrival and a dismissal. So, and then when that case actually gets registered with the proper data, that is treated as a new arrival. So there's some amount of what I would call as double counting. So we didn't have that in our data. And because we downloaded our data from the case status page of the Supreme Court, our count looks different, but I don't believe it's inaccurate. I think it depends on the accounting scheme, but this is what the arrival rate is, roughly around 40,000 new cases a year. And as I mentioned, because our focus is on appeals, we are thinking mainly in terms of adjudicating as 2 judge benches. So as I said, the idea is to replicate or mimic the performance of the Supreme Court in a way that we understand congestion. So not a digital twin, which sometimes a simulation model is called because it replicates the performance exactly. I would say we have a digital cousin, which is a closely related entity to the actual Supreme Court. So in what ways is it a cousin? So we have, because 28 judges at the time we undertook the course, for the project, 14 two-judge benches. So no three-judge benches in our model, no five-judge benches, no constitutional matters separately. Also, no retirement of judges and no new appointments. The data is available. I could model that and build that into my analysis, but I don't think that drives the congestion. It just makes it harder to understand what is going on. So for that reason, we didn't model retirements or appointments. They are disruptive. So if you had questions about that, we can talk about that. The second thing is that we know there are different types of cases in the Supreme Court, civil appeals, criminal appeals mainly. But we treat the cases to be homogeneous. Why is that? There are a few reasons. Some are related to complexity of modeling, some are related to data shortages. I'll describe what I mean by those. So essentially, homogeneous cases, and each case goes through two stages. The pre-admission stage, where we refer to matters as fresh matters when they actually come in, and after notice matters, after notice has been issued to the parties litigating. And once the Supreme Court determines that this case requires closer scrutiny, it admits the case. So thereafter, it's handled differently, sort of. And the second stage of the queue shows up, which is the post-admission stage. Like I said, we do not distinguish between different case types. We just call a case a case. Why is that? One of the key components that we needed for our analysis was the hearing time associated with cases. So how much time does the Supreme Court panel spend actually hearing the arguments, etc.? Now, the way to do it is, this is where Surya had helped us. He had pointed us in this direction. And the way to do it would be to tap into the digital clock, which you can, the online display board of the Supreme Court. So we did that. However, the data over there, besides the time of the hearing, was inconsistent. Sometimes you got details about the case, sometimes you didn't. So it's very hard to say what type of case was being heard. So that was one of the reasons we didn't want to get into different type of cases. But also equally, remember our focus? Our focus is on what drives congestion, and it's an aggregate level analysis. We're interested in overall congestion at the Supreme Court. So knowing the relative congestion between criminal and civil appeals wouldn't be as useful for that purpose. Now, one could say I'll prioritize cases in a certain way. That itself is controversial. We know that this Chief Justice of India exercises their discretion to prioritize certain cases, and there are scholars who have critiqued that and have expressed concern about that, so we didn't want to get into that. Moreover, because we're replicating the performance, we don't have any way to capture the Chief Justice's discretion in the data. So for all of these reasons, we did not try to model different case types. Also, we have no stay orders. We had an 8-year horizon in our data. Stay orders often go beyond 10 years. And in that sense, maybe the average turnaround time or average delay of cases in our analysis is a slight underestimate of what it might actually be, because we've left out cases which are under stay order. So the main idea, as I said, was to identify the factors driving congestion in this digital cousin. I'm going to skip over the literature except to acknowledge Professor Chandra's work, who has looked extensively with her co-authors Sita Kalantri and Will Hubbard at the Supreme Court from an empirical standpoint. So in that sense, I view our work as complementing her work, where we are kind of trying to use the data again to not only capture Supreme Court current performance, but maybe conduct counterfactual analysis. What if we had tried different interventions? Would the Supreme Court had performed differently? So moving on from the literature, this is a schematic of a queuing system. So on the right side, you can see here, I'm representing benches, and I said we model 14 two-judge benches. And this is the common queue of cases, right? So cases come in, this is the waiting line, the rectangle. However, the Supreme Court is a much more complicated version of this queue that I'm just showing you on the slide. It looks more like this because there is a separate queue for pre-admission cases, the fresh matters and after notice, and there is a separate queue, which is on the right side, for post-admission cases. So cases come in, join the queue here, wait their turn, they're assigned to a bench. If they need multiple hearings, they go and join the queue again. Ultimately, the court decides either to dispose the case or admit it to the second stage. And if it gets admitted to the second stage, once again, it can have multiple hearings with its assigned bench, including adjournments. And then finally, the case gets decided. So it's a much more structured interaction in a queuing system, right? Everything follows a particular sequence of events, and that allows us to analyze it more systematically and mathematically. Having said that, because of this structure, it doesn't incorporate the Chief Justice's discretion in scheduling cases, etc., or admitting cases for that matter. A few features which I think are important and worth highlighting is that after a hearing is done, sometimes the case is not available because maybe the parties have to go and find documents, go and do some tasks or the other. And the Supreme Court says, list the case after 4 weeks, list the case after 6 weeks. You cannot schedule the case for its next hearing in this time window. So we had to capture that. And that obviously constrains the functioning of the Supreme Court. So we refer to that kind of time window when you can't schedule the case as external delay. And we captured that through the order files. So the order files in the Supreme Court, the daily order files after every hearing, would give information about how much external delay there might be. The other aspect, which is really crucial for this research, is that the judges have to split their time between stage 1 cases and stage 2 cases, right? It's the same panel of judges. So, for instance, loosely speaking, Monday, Friday, let's hear stage 1 cases. Tuesday, Wednesday, Thursday, let's hear stage 2 cases. It's not quite like that, but I wanted to give you a sense of how the resource was being shared across stages 1 and 2. And finally, and this is also a big contributor to inefficiency, is what we refer to as forced idleness. So we know that there are these cause lists because of which, or not because of which exhibit advanced scheduling of cases, right? So we release this cause list and parties know when they have to show up in court, etc. They have to travel sometimes many days from different parts of India. So this has to be done in advance. But let's say the number of cases scheduled in a day get wrapped up earlier than expected because the amount of time you spend on a hearing is random. Sometimes things get adjourned. Then it is not easy or impossible sometimes to find a case instead. So what's happening is, at least from a processing of cases standpoint, the judges are forced to be idle. Even if there is a huge backlog of cases, that day they cannot hear a new case. Now, in literally speaking, they're not idle. They're probably doing all sorts of other work, but they're not adjudicating the next case. So from a congestion point of view, it is a substantial constraint. Like I mentioned, in terms of the data that we had 8 years of data, which we downloaded from 2009 to 2016, and roughly about 40,000 cases per year is what we got. In terms of the hearing times, we tracked the online display board for a period of 6 months and collected about 16,000 observations so that we could model the hearing time. Thereafter, we did a keyword analysis of the daily orders, right? So once we had all of the data and we looked at every order during the lifetime of a case, which is the daily orders, and based on the wording of those orders, we figured out what was the outcome of that hearing. What was it? Was it an admission decision? Was it a disposal decision? Was it a regular hearing? That means the matter is incomplete and has to be heard again. Or was it an adjournment? So what I'm showing you on this slide is post 2015. We segmented our data into two buckets, pre-2015 and post-2015, because there was some amount of change in the numbers in these two time windows. What is remarkable, obviously, is if you look at the adjournment probability. So in stage 2, 57% of the hearings are adjourned. Even at stage 1, it's 37%. That's a huge number, right? And we know that the Supreme Court at some points in time had suggested no more than 3 adjournments per case, but difficult to enforce. And right now, nothing close to that number is being seen in practice. Okay, so all of that data being collected, we wanted to benchmark against the metrics. So that's how we would get the confidence that our queuing model is a reasonable model. It's not perfect, but it's coming close to how the Supreme Court is operating. So when we looked at the data, the expected case disposition time from when it came to when it was disposed was about 275 days. Cases with excessive delay, which is, we defined that as 2 or more years of delay, there were 13% such cases. But note that we had a snapshot of the data from 2009 to 2016, and we were not looking at cases with stay orders. All those things would make these metrics worse. So these are the metrics from our data. Very importantly, I think, in my view, summer vacation was being used to adjudicate cases. So about 1,000 to 2,000 hearings happens during vacation times. Where did we pick that up from? From the annual reports. In terms of how the judges split their time, on Mondays and Fridays, as I had mentioned to you, they listen to arguments about pre-admission cases, fresh matters and after notice. In particular, the guideline from the procedure handbook is that 45 fresh matters are scheduled and 15 after notice matters are scheduled. Tuesday, Wednesday, Thursday is quite another story. The guideline in the procedure handbook is that you should schedule 10 after notice matters and 10 regular matters or post-admission matters. The reality, as pointed out by various scholars, is quite different. The CJI, the Chief Justice, exercises a lot of discretion, and the numbers of scheduled cases are much larger. Regular cases are between 10 and 20, and after notice matters, that's basically up to the Chief Justice. It could be as much as 30 in a day. So it's very different from the guideline. And you'll see why that has to be the case. The guideline is just not up to scratch in this case. What in the end we assumed, remember I told you with the hearing time, we're not able to distinguish between post-admission cases and pre-admission cases. So we just assume homogeneous hearing times. So for that reason, if there are 60 cases on Monday, Friday, then it stands to reason that there should be around 60 cases on Tuesday, Wednesday, Thursday. But the split between after notice and regular matters, like how many of regular matters and how many of after notice matters to schedule on Tuesday, Wednesday, Thursday is critical, because that is determining how much time the judges spend on stage 1 versus stage 2. And you'll see that matters a lot. So the most obvious intervention, I guess we're towards results. So fine. Thank you for being patient about this. The most obvious intervention is to add judges. And does that have impact? And what is the bang for buck here? It's a very costly intervention, right? It's not easy to get more Supreme Court justices. But let's say we could. Then the most obvious thing to do would be to add 1 judicial bench in our analysis, right? So 2 more justices. And let's see if that gets rid of the problem. And it doesn't seem to matter a whole lot. The average delay when we added an extra bench went down from 275 days to about 252 days. So that really isn't bang for buck. The holiday hearings, they decreased from 1657 to 84 per year. So there's some improvement, but not as much as one might have hoped for. And the reason, through this image, I'm going to try to explain the reason. So if you think, if you look at this sink, it's backed up. There's water clogged over there. And you would guess that the drain is clogged. That is the capacity at stage 2 for post-admission cases. So you say, let's increase the size of the drain. So give more capacity to stage 2. But remember, the judges are shared resources. So when you add a judge, you're increasing the drain capacity. But the judges are also the tap. They are also providing the input of stage 1 cases which are being admitted to stage 2. So when I increase the drain size, I'm also increasing the speed of the water coming from the tap. So in the end, congestion is not going away easily. Now, of course, if I add even more judges and even more judges, the problem will go away. But for small changes in judicial capacity, we won't see dramatic benefit. What gives us huge dramatic benefit is alleviating the stage 2 congestion by rebalancing the judge's time. So on Tuesday, Wednesday, Thursday, change the split. In our baseline case, the split we came up to match Supreme Court performance was 45 after notice cases and 15 regular or post-admission cases. With that, we were able to match the Supreme Court performance. You change that split slightly, as shown on this slide, to 17 after notice cases, 17 regular cases, so give more capacity to stage 2, and only 43 after notice cases. So it's a very small change per day, and you just get a tremendous bang for buck. The expected delay goes down from 275 days to 95 days, so maybe around 65% reduction in delay. Those cases which are delayed beyond 2 years, in our simulation, it was at 17.6%, even though the data was giving 13%. So our simulation couldn't exactly track that excessive delay. If you're more interested, I can explain to you. I think this is a robust number, 17.6%, but it almost disappears. So no case is excessively delayed. And the holiday hearings disappear. The forced idleness, which I had talked about earlier, used to be 14% of the judge's time. It goes down to 12%. So only slightly goes down, but delay almost, we've almost resolved the whole delay problem in this counterfactual analysis. Of particular note is the holiday hearings going to 0. So why I'm emphasizing that, even though it's not a whole lot of time spent hearing cases, is that the stage 2 is overloaded. You don't have enough time to process all of the cases. When that happens, your congestion should grow without bound, without limit. Yet, if you look at the annual Supreme Court statistics, everything is stable. It seems like we are in control. We adjudicate more cases that are coming in. The way that is happening is by tailoring the holiday capacity. So to prevent the explosion of the queue, the hearings in the summertime or vacation time are trimming the excess workload. Once you get rid of that excess workload, your queue will explode. So if you do an intervention like what we're suggesting, which is rebalance the time between stage 1 and stage 2 cases, then you don't need holiday capacity. Your queue is stable once again. So the main insight from here was that you need better guidelines for how to split the time of judges from stage 1 to stage 2. So on Tuesday, Wednesday, Thursday, how do you split your time? On Monday, Wednesday, how do you split your time? Better guidelines are needed, maybe from a framework like ours in this research. And we provided some mathematical analysis of how those guidelines could come. One obvious thing which you should be able to relate to is that however the judges split their time should be a function of the number of judges and the number of cases coming in, right? You would agree that however we split the time should be a function of the number of cases that come in and the number of judges that are active in the Supreme Court. They're not, they're static. Right now, the 45-15 split on Monday, Friday is static. There is only something like a 10-10 split recommended for Tuesday, Wednesday, Thursday, with a suggestion that the Supreme Court Chief Justice can use their discretion. So there is definitely a need for more guideline here. And what I'm suggesting to you is that it's causing a whole lot of problem. So it's a big deal according to us. The other thing I thought would be interesting would be to see if we intervene on the adjournment side, just reduce the adjournment probability. Because stage 2 is overloaded, not stage 1, reducing the number of adjournments on stage 1 doesn't help reduce delay. But in stage 2, the lower panel here in this figure, if I reduce the adjournment probability just by 5%, I've almost eliminated the delay. So I have to reduce the number of adjournments in stage 2 only slightly. It used to be 57%, as you saw, the adjournment probability. I have to reduce it only to 52%, and the delay goes away because stage 2 is overloaded. And how could you do that? That's a good question. And we thought, scholars have already identified this notion of superstar lawyers who are scheduled multiple times during the day and that they can't be in two places at the same time, so they request an adjournment. Well, why not anticipate that upfront, perhaps, and don't schedule superstar lawyers for multiple hearings at the same time? Maybe something like that. I don't know if that's you can operationalize it, but that's an idea. And then you just have to reduce adjournments by 5%, and that could give a lot of benefit. So in conclusion, we benchmarked against status quo to understand the drivers of congestion, and we found that how the judges split their time between stage 1 and stage 2 is a key driver of congestion. Holiday capacity is very deceptive. So the holiday hearings are giving us the impression that everything is in control, when actually they're hiding the fact that stage 2 is overloaded, also taking away valuable time from justices when they're supposed to write judgments during the holiday time and supplanting that time with more hearings. But then we saw that adding a few number of judges will not give us huge bang for buck because the delay is insensitive to small changes. And remember that analogy with the tap and the drain, that comes into play. The timing of adjournments matters. Stage 1 adjournments, not as crucial as stage 2 adjournments, right now at least. And so intervening slightly to reduce the number of stage 2 adjournments can give huge benefit. Changes in capacity when we appoint or retire judges has to be complemented with revisiting the scheduling guidelines. So how you split your time on the days of the week between stage 1 and stage 2 has to be a function of the number of judges and the number of cases in the system, or the arrival rate, not pendency. So in summary, what we've done is we've applied knowledge of service operations to this judicial setting, the Supreme Court of India. It's a case management queue where you go back to the same panel. You don't go to whichever panel is free. In that sense, it's a systematic framework for capacity planning. Can we use this approach for lower judiciary is the, I guess, burning question in our minds. So with that, I will stop here and allow you to ask questions, or perhaps the discussion goes to Professor Chandra and Siddarth Raman. Thank you.
Thank you, Professor. I'm pretty sure it's very hard to summarize such a big study in such a small time. So I would want to hand over the mic to Professor Aparna first.
Thank you. Thanks, Rohit. Thank you, Professor Bakshi. That was a very interesting talk, and I loved reading the paper. As Rohit already mentioned, and as you did as well, I work with data, and I've looked at data on the courts. So I get very excited whenever I see new work out, because there are very few of us doing that kind of work. So, and I'm particularly excited by the data innovations that you've done in your project, and I hope you are planning to take that forward, or you're planning to use all the data that you've already gathered as training data for, probably training AIs to sort of examine cases and multiply the ability to engage with that kind of granular understanding of cases through court orders. I know there are lots of people who are trying to get into that space and doing work, research work on this space, and we're all sort of figuring out where that kind of training data might come in. So I think there are great possibilities there just with the data that you've gathered. Given the multidisciplinarity and interdisciplinarity of this panel, I think I'm the lawyer on the panel. And so I'm very well aware of the complexity of the system. I am not as aware of simulation models as a way, as an approach to studying complex systems. And so my questions come from a place of curiosity to learn more. So pardon me if some of what I'm going to say is off the wall. So there are a few questions that I had, and then a few worries, concerns that I had. The questions that I had were about some of your assumptions in your simulation model. The first, of course, being on bench homogeneity. I did wonder if you looked into, I didn't see any discussion of this, so I was wondering whether you looked into the question of rostering at the Supreme Court, and whether that played any role in how you, in your simulation, because it's not as if every new case, in what I was able to understand from your appendix, in the simulation model, fresh matter, for example, would just go into the shortest queue, regardless of which bench it is, or even a post-admission matter would just go into the shortest queue. But we know that that's not how case allocation happens at the court. It happens through a roster of subject matters, which is pre-announced, it's available on the Supreme Court website. So we do know that a criminal law matter is going to go to one or two or three of these benches. It's not going to go to just any other bench. And so if, for example, I mean, hypothetically, if the pipeline is full of criminal law matters, then we are likely to see greater congestion with respect to criminal law matters as opposed to civil law matters, or greater numbers of cases in the civil law, in the criminal law pipeline as opposed to the civil law pipeline. It might not lead to greater congestion, but definitely greater numbers. So I wonder if that's factored into how you've sort of done your simulation. The second is with respect to case homogeneity. Now, again, this is my lawyer hat on. The idea that we treat all these cases in some senses as homogeneous strikes at the root of all my training from when I was an undergrad student. So again, bear with me for my questions here. But first on pre and post, right? I mean, as your own data shows, your pre admission hearing, you're finding a, if I remember correctly, your mean time is about 1.46 minutes, and your mean time for post-admission matters is about 17 point something minutes. But one of the things that happens with the pre-admission stage, we know, at least my own work has shown, that about 86% of all fresh matters are dismissed. What we in law we use the phrase in limine, right, on the first hearing itself, within a matter of a few seconds, right? So the judges have generally made up their mind. They have to give an oral hearing to every matter. And this is policy. This is just because there's policy, not because there's anything that's necessarily compelling them to do that. But they give a hearing to every matter. But for the matters that they are going to reject, they reject them within literally a few seconds. And so these matters, which are the bulk of the fresh admission matters, would have a very, very short time. Whereas your after notice matters, where you may end up having sort of a mini trial of the main case, would take a much longer time. And I wondered if sort of clubbing all of these together is likely to sort of create a this one of those genetic sort of changes that happens between cousins, but of a nature that may make the simulation model, to the extent that the model should, in some senses, reflect the reality. I wonder to what extent that similarity would continue to exist. Similarly, with different subject matters on civil and criminal matters, I was wondering if I know you sort of ran the tests for this to see that actually the time taken by civil and criminal matters is roughly the same. But again, I was wondering, given that criminal matters themselves are not like just this one homogeneous class, right? There are minute applications, sort of bail applications. In civil matters, there are these transfer petitions, which are decided very quickly, versus like the full suit being decided, or a full sort of murder case, the court having to determine whether the person was rightly convicted and sentenced to death, is going to be a much longer case. So I just worry that internal to civil and internal to criminal, there might be a great level of heterogeneity, and accounting for all of this in the same as homogeneous might be a problem. Now, I absolutely understand that your data is not granular enough, but in fact, there is work that has been done, and if you plan to sort of do that kind of data work in the future, you may profitably sort of look at that. My colleague in my law school, Rahul Hemrajani, and his co-authors have this fantastic paper where they start with where you started, looking at the digital display board, but then they correlated that to cause lists for the day. So then for every case matter, right? So A1, R1, whatever it is, the nomenclature that the Supreme Court uses, they on the cause list can see what is the exact matter. And then they pull that out from the Supreme Court website. And so they knew exactly what that matter was listed for that day, and what is the subject matter category, what stage it is at, so on and so forth. So that's, and their work was also, I think, the paper came out in 2020, if I'm not mistaken, or 2020 or 21, but I think that their data sort of is from the same, roughly the same time period as yours. So that's maybe a conversation worth having with these folks. The other question was about, you mentioned, and you mentioned in your paper as well, that there is complex systems are complex in their different ways, but there's some similarity to the complexity. And you use the example and the analogy of the medical system. And that is the analogy that got me wondering about triaging, right? There might be good reasons for some cases to be jumping the queue, not jumping the queue, etc. And I know that you've not looked at that, but we know that this is something that courts do routinely. In fact, the big headache for every CJI coming in is listing and mentioning, right? The whole thing of how do you list cases on priority, and used to be a time, in fact, probably in the time period that you're looking at, where the first hour of the Chief Justice's work day in the court was spent just allocating cases to be heard on priority. Every bench has that priority thing, and they've tried to make changes there now. But I wonder if that kind of triaging is something that needs to be accounted for, both in terms of what is actually happening in the court, but something that a simulation model should take into account in any case to see if the findings are in that sense robust. The larger question I had was about the link between hearings, delays, and congestion. And I wonder how robust that link is. Because hearings are one set of episodes that happen in the timeline of a case, right? These are, FaceTime opportunities with the judge. But there's a lot of filing that's happening. There's a lot of other things that are happening at the back end with respect to exchange of documents, submissions, so on and so forth. And ultimately, the decision itself will not come on the day of the last hearing. There's a gap between, for matters at least that get into the post-admission stage, there's very often a gap of up to 6 months between, and the Supreme Court has sort of capped it at 6 months, but there are exceptions still. Between the last date of hearing, then the matter is reserved for judgment, and then you get the judgment when you get the judgment. The reason why I'm asking this is that there is an assumption that is being made that the delays are that somehow hearings themselves, and just plotting the hearings, which is this one middle part of the case, can give you some sense of delays and can give you some sense of congestion in the system. And I'm just wondering if that connection holds holds good, and I would love to hear your thoughts on that. The reason why I worry about this is, for example, you're finding about post-admissions congestion, right? And that a small tweak in terms of, say, adjournments or the split between pre-admission and post-admission matters can have a huge impact on that congestion. But I was wondering to what extent that congestion is sort of because there are too many cases in the queue. To what extent are they because of the games that lawyers play? And this is where I wonder, I wasn't very clear what it meant for you to say that you've not looked at stay orders, because the name of the game in Supreme Court litigation, where the big bucks are for lawyers, is notice and stay. You get notice issued to the other side, you get stay on the lower court's order, you've pushed the can down the road with respect to your legal liability. You won some relief for your client. So that's the big that's the big money spinner. That is where the big bucks are. That is where the grand advocates have the greatest influence. If that is the case, then lawyers play these games where they want more delay in their cases. And I wonder to what extent changing sort of these kind of alignments will result in lesser congestion in this kind of a sort of, with this level of certainty, right? That was really my question, that the level of certainty that this sort of in your model is, for me, I mean, I'm just thinking of all the complicating factors because of which, even if the model were to hold good, the incentives of parties and the incentives of lawyers would operate in distinct ways. And, I was thinking at the beginnings, Rohit was mentioning this work that Siddarth's involved in Pukar, and I have a ringside view to that project. And I think it's this constant battle between designing a robust system and then knowing that it will be subverted in all the ways in which it can be subverted, and then designing around it, right? So this is what I was wondering. I was wondering, to what extent does it take into account motivations? To what extent can you take into account motivations? To what extent can you take into account incentives and disincentives? The reason why I mentioned this is that there's a larger trajectory of judicial reform which sort of pushes for these sort of managerial, sort of operational kind of changes as the mode of sort of judicial reform, right? To reform the process. This is all that is needed. It's business as usual, tinker a little bit here, tinker a little bit there, and you'll have outsized benefits. And we've seen much of that tried and failed because the system adapts and the system players adapt to those changes in order to play the games that they are playing. My worry is that for lawyers who are not trained in data, and particularly for judges, it's presented the way it is presented, are very likely to jump on this and say, oh, hey, if we do this one minor thing, we'll have these benefits, and then we don't have to do any other changes. And there's a lot of literature out now which is sort of looking at some more fundamental reforms in the court in terms of rethinking whether it should be an appellate court, right? Or whether it should be the appellate court of the size that it is there, because that's the fundamental problem. If you take away, if you start, there are many cases that are getting crowded out right now because the court is because the court takes a lot of time. If the court starts taking less amount of time, there are more cases that will come to the court. And if the court is not tinkering with its admission criteria, then that problem will just sort of manifest in different ways. So I know it's not your burden to sort of think about how your data might be misinterpreted. But I just worry that this sort of fits into a very a tendency within judicial decision makers, judicial administrators, to think about managerial solutions to what is also a culture problem within the legal culture, within the litigation culture, and that they're likely to see nothing of all the qualifications that you have, but just the just the findings and act on the findings. And so I wondered if you would want to sort of qualify your findings in terms of sort of the kinds of limitations that a simulation model generally has, to the extent that any of this is sort of, to the extent that this paper is geared towards that judicial audience that is not necessarily trained in simulations. I am going to stop there, but happy to sort of pick up on any of these threads during discussion. Thank you.
Thank you, Professor. Professor Bakshi, would you want to give a quick response? Because we have even Siddarth to give his input, and then also we have to move on to the audience question also.
Yeah, to keep it short, because otherwise I guess we'll lose the flow. Maybe a couple of points. Rather than go into detail, I could respond to the points in detail, but maybe we do that at a later juncture. High level, the fact that the Supreme Court thinks access to justice is important for it, we are taking that as given. Not to preempt that debate, as you pointed out, we are, in this research, we are saying, okay, that is outside the scope of our discussion. Given that the Supreme Court wants to be a court which provides access to justice and the workload and wants to be an appellate court for that reason, what are the drivers of congestion? So not necessarily to be a perfect prediction of the delays by case type, but at an aggregate level across cases, what are the drivers of congestion? So in that sense, we have sacrificed the ability to be accurate to by case type, because the goal is not necessarily to predict delays by case type, but just to look at high level, how can we manage the court better? So all of this, then we try to see whether our assumptions interfere with this result, that the second stage is congested, and interventions to avoid that congestion will give huge bang for buck. For instance, you mentioned we have assumed case homogeneity, and the time of pre-admission hearings is short, post-admission hearings are long. So we've tested for the robustness of our insights to all of these assumptions, or homogeneous benches for that matter. No, homogeneous benches, there's another concern. We don't have the visibility into scheduling of the benches. It's a very complicated problem. So getting into that level of detail would be prohibitively costly without necessarily, in my view, changing the high-level insight on what is causing and driving the congestion. Then there were some questions about, there are all these bunch of other things that are done in the Supreme Court, like filing and documentations. Those, so the two things to look at over here, that the bottleneck resource is the judge's time. So in that sense, if you alleviate the bottleneck, then you'll bring about benefits. But there are delays caused by, like you're saying, you gather information, etc., file documents. Those we've tried to capture through what I had referred to as external delays. So when the Supreme Court says, look, there are certain things you need to do and take 4 weeks, 6 weeks to get this done. So we've accounted for that. And in those 4 to 6 weeks, when the case is, when the lawyers are working on these aspects of the case, we are not allowing our simulation to schedule that particular case. So it just remains in ether outside the system until that window expires and it's available again. Stay orders, yes, we did not model stay orders. And to that extent, our metrics of delay are a slight underestimate. But my sense is that the number of cases that we've left out with exceptional delay, like of the order of 5 to 10 years, are not that many in terms of how much time they need for adjudication. So if we free up time at the Supreme Court, then that should make more time to look at these cases, including constitutional matters, which are of great importance. So at a high level, I wanted to sort of reiterate that the goal is just to understand the drivers of congestion. You made another very interesting point, which was the various incentives of the various players. And it's impossible to capture that in a data study, except the way we've done, I think. And the way we've done that is that we look at the outcome probabilities, right? So what is the probability that the case gets adjourned? Now we know that the adjournment decision can be a game. But whatever games they're playing, in the end, it results in a 57% chance of adjournment. So while it's a simplified model, it is trying to capture what happened in this time frame from 2009 to 2016. Going forward, if we propose these kinds of outlandish or big benefits, and then people react strategically, one way to think about it is that more cases might get filed. And that's fine then, right? So given this current caseload, this is the best way to operate, is our sort of assertion. If you take on more cases and the delay goes back to being 275 days, then so be it, but you're now adjudicating more cases. So rather than think of the benefit in terms of lower delay, perhaps you could think of the benefit then in terms of more cases adjudicated. And then it does have some limitations for sure, in the sense that will stay orders become more? I don't know. I don't have answers for that. Yeah, we're looking, our approach is more from a logistics standpoint. And yeah, I'll leave it at that for now, but we can come back to some of these questions. I hope I put some structure to the discussion, I hope. Yeah, I suppose Siddarth had a bunch of points, and we could come back to these.
I'm going to share my screen. Can y'all see this? Can y'all see my screen?
Yes, we can.
Great. So I want to start off by saying I think just this approach is fairly cool because it tackles a very important question. It applies operations thinking to real world problems, which is an insanely hard challenge. And applying queuing theory to model case flow is a fairly fascinating idea. More importantly, it creates a sandbox or a data-driven approach to evaluate a fairly complex resource-constrained problem. So echoing what Professor Bakshi said, identifying the bottleneck, solving around that, I think that's useful in how court administrators can use some kind of data-driven insight to take some decisions on court capacity, listing, scheduling, or at least the use of data to make such to understand the state of the world today, and then saying, okay, if we are able to get a model that simulates the real world to a fair degree of accuracy that we can all agree, then can we then play around with some of these assumptions? And I think that's a fairly novel way to approach this question. My background is in engineering and management science, and I did not do well at operations research. So most of my critique is not going to be on the insights or the what Professor Bakshi talks about in, okay, based on this, what do our simulation results yield? Most of my comments are only going to be about what kind of inputs could make the inputs going into that simulation a little better, because I trust whatever results have come out are robust from an operations standpoint. So my questions and observations are mainly behind our attempts to do some kind of modeling and what data is useful and what is not. And I think I have a lot of sympathy for Professor Bakshi when he's done a two-stage model, not controlled for case type, not controlled for all the things that there are caveats for, because the hardest challenge with modeling is balancing accuracy and simplicity. Ideally, every lawyer will tell you every case is unique and n equal to 1 and very case facts. And the burden is to kind of, balance this out. So let me caveat this with, I understand that all models are wrong, but some are useful. And with that in mind, the hard challenge is how do we take messy court systems, put clean models, write nice math equations, right? So what I'm going to cover is mainly some questions on what are the assumptions that have gone into this model, how some of the derived insights, can they be ground truthed with practitioner experience to make the model more robust with better data inputs? And how can we build on this type of approach? In what manner? And addressing the question of what is the challenge in taking this outside the Supreme Court, right? So I'm going to take the fact that the results of this model are granted, but then talk about, okay, how easy is it to extend this? My major nit is on, and this is actually more of a question, because when I read the paper, I felt that you all were using the order data, which is to say list within 4 weeks, as the metric to model external delay, or what I've been calling time between hearings. Now, and I make this assumption because the measures of this data are also reported in weeks. So that's one major sort of highlight that I want to just discuss, and it'd be great to understand what that approach was. I'm not in step 8 of the appendix. There is a carryover time, which is if a hearing carries over. I didn't understand that. I didn't understand the utility of that small adjustment. And we'll talk about some of this. So the distinction is that using orders, when the order says list within 4 weeks, it isn't often listed. So actual here listing times are often variable. So, when I think the data reports are 4 weeks plus or minus, or whatever, 3.4 weeks plus or minus 5 weeks. With a standard deviation of 5 weeks. Whereas I think it's all much more variable. So if the source of external delay is actually reading the orders, I would urge you to take the actual listing dates, because you have the data of the order, and the date of the actual hearing is a better source of external delay than the order text. So you have both sources of information. I just wanted to confirm that you're not using the order text, because the order text is often incorrect.
So maybe I can just clarify. No, this external delay we just used to say that the case cannot be listed in this window. After that, the case joins the queue, and it's turned whenever it comes, when it reaches the head of the queue, that's when it gets listed.
So that assumption of 4 weeks, I would say that perhaps a better utility could be taking actual case lifecycle data and modeling out the time between hearings, and then using that as the time in which it cannot be listed. Perhaps that's one way. The only idea is what's possible is that some of this may be crashing, or it may be increasing the frequency with which cases are listed, whereas cases are listed quite far apart. So, as an example, when I just took some random case on the Supreme Court website, this says 2023 and it says list after 4 weeks, but it's actually listed in 2025. And
that's consistent with what we find. Yeah.
Okay, fair. So, so you're saying that the assumption, this does not make a difference to the modeling itself.
No. So I'm saying that we did not model it the way you're thinking, that, after 4 weeks, we list the case. We just said, for these 4 weeks, the cases cannot be listed. Then after that, it can potentially be listed, and actually it could get listed much, much later, just like
based on where it is in the queue.
Based on where it is in the queue, that's right.
Fair enough. Okay. So the other question, I guess if you're not modeling time between hearings, it doesn't matter. But okay, so all of this was just, so perhaps it might be useful to add another stage to say whether listed, because you have a condition which says everything comes, and maybe you have a bifurcation of disposed, regular, hearing, and adjourned, and maybe it might be useful to add one more stage in the middle to say whether it's listed, and if it's listed, is it heard? And this is perhaps something that could make a difference. I'm not so sure, but I guess the way you're modeling it is not this way of when it is listed is not something that you're trying to.
No, we're not reporting that statistic, but we model it just like you're recommending.
Okay. And okay, then I was kind of perplexed by this carryover time. I didn't understand why it was relevant to the model. So there's a point in step 8 of your appendix which says that, okay, if there was a hearing which was part heard, part of that hearing is then taken over, carried on to the next day. I wasn't sure why it was useful. So I also understand that you have tested for robustness in Appendix C, saying that, look, if we had controlled for hearing outcomes across post-admission, or whether you had controlled for hearing time between pre and post-admission and across hearing outcomes, it's not really making a difference to the simulation model. My question to you was more, did you see a strong problem with using sparse data? Like, I understand you chose not to simplify it and then make robustness checks, but to a judicial audience, to a audience which is of legal mind, it is perhaps easier to present that, yes, we cut the data and use sparse data, instead of saying, okay, we didn't use sparse data for the sake of simplicity. It might be a messaging thing based on whether your audience is an operations audience or a legal audience. Because I'm assuming a legal operations audience might say, statistically, the number of data points are too few for you to actually cut the data and, you know, make hearing time specific to post-admission, pre-admission, by type of hearing, whether it's an adjournment or not.
I mean, I should clarify here. So with respect to carryover, not a problem. It's just the part heard matter, right?
Yeah.
So I agree with you. It's some very minor adjustment, is not a first order effect, but we just wanted to be coherent. So in the sense that, let's say there was a hearing which was incomplete on the previous day, then the next day, if it is taken on for hearing again, then okay, only the remainder of the hearing time would be you use the next day. So that's all. But if we did not do that, I don't think it would change the difference. Yeah. With respect to sparse data, are you referring to case type heterogeneity? Are you saying that
Case type heterogeneity? So you take a number of about 6 minutes per hearing time, and this is standard irrespective of pre-admission or post-admission. And I think this is also standard whether it's an adjournment, whether it's a disposal or a regular hearing. And you control for this in Appendix C by saying, look, we've run robustness checks. It doesn't matter. It doesn't impact the model. This is just a suggestion on how it's presented to a legal audience. And you explain that our data points are too sparse. So, you know, should we be really using it? But to a legal audience, it might make that difference to actually use the sparse data. Instead, it's something for you to consider.
Yeah. I mean, no, I think we approached it differently. Not differently. I think maybe you got it. And I'm aware of this fact that, you know, from a legal audience's standpoint, if it's not fully realistic, they are worried that something is amiss. What we did was robustness checks, as you're saying, which is let's assume that sorry.
Yeah, no, so I got it, right? Because I thought of this question and then I looked at your appendix and I said, yes, so have they. And they have clearly thought about that other people are going to ask this question and they've controlled for it. But from a messaging standpoint, it just might make
I appreciate the feedback.
Considering a different audience.
Siddarth and Professor, we have only 15 minutes. Can we just...
going to wrap up very quickly, okay? Less than 2-3 minutes, okay? So one is there are some inferences that I was looking at, and I'm assuming these have been ground-rooted, that the percentage of admitted cases, I think Professor Chandra just said that, yeah, most cases were dismissed, so maybe that admission rate is perfectly fine. I was looking at the number of hearings pre-admission and post-admission, so I just took 1 divided by the disposal to come to the number of hearings that it would take you to a disposal. And I arrived at, in a pre-admission stage, 2 to 3 hearings, post-admission 11. If that's useful to cross-check with practitioners, that's interesting. I just had one point on the 275 days. It would be useful for you to check, if you have not, that these are main cases. So we ran into this problem in Bombay High Court, that there are interlocutory applications as part of a main case. And then there is the main case itself. So if a main case lasts 300 days, but it has 9 interim applications, each lasting 30 days, when you do an average or a median, you would get 57 days or 30 days, based on whether you did average or median. But the actual answer is the case took 300 days. So just check that when you're aggregating across case types, you're not taking the interim cases. It has biased my analysis of high court data very often. I was fascinated by the ability to come to judicial time, total judicial time, as the right unit of analysis, right? So let's assume that we're able to get the right amount of granular data to actually look at number of hearings and actually get to time spent in a hearing. You can then construct the life cycle of a case in minutes and talk about how it has been fragmented across years. So I think that was great that you're able to do that kind of, of course, you will get more granular as you get more data. The second question was, in some of these, you have made some assumptions of either normal distributions or geometric distributions of how cases go through. It is a question to say, do you think using non-parametric models might be better? So for example, instead of using time to disposal, we have always been using survival curves, because there are a lot of cases which are not disposed and we don't know the shape of the distribution. So we don't use so it's a thing to consider that when you're modeling some of this, perhaps some non-parametric models might be more useful.
It's all non-parametric, Siddarth.
So the normal,
I didn't assume normal anyway.
distribution assumptions anyway.
No, we didn't. So the hearing time distribution is non-parametric.
Okay.
The inter-arrival time is whatever the data says, so non-parametric.
Understood.
I'm not sure where we might have used parametric. I can't recall any, but
the
I
standard
think
deviation of your 4 weeks and 6 weeks, and I assumed you were plotting it as a normal distribution.
so outcomes we would give you that statistic. So once we've simulated, then the outcome distribution, whatever was the standard deviation, we would mention. But in terms of the inputs, we didn't assume any parameters.
And I believe that, with more data, you will be able to model more granular assumptions as you see fit. So multi-stages, case types, bench variability, hearing outcomes. The challenge in High Court and District Court is that you don't get this hearing time number, and because they don't have display boards. So when we had to do District Court, we had to sit in court and note down these manually. It was a pain, and cases take less than 30 seconds sometimes. When we try to introduce, or we've seen how they use the tech systems, they use the tech systems after court hours. So, doing live edits on time, it's a challenge. My conclusion is that I love this idea. I love the approach to applying this. It's a really strong foundation because we can keep tweaking some of these models to then try and get as close to a model of reality, because that allows you to do experimentations like, should we add more judges? Should we have fixed amounts of time, and all the other applications that Professor Bakshi mentioned, without actually taking the effort of doing it, which costs a lot of more than money and time, political economy. Because once you blunder your way through it, as Professor Chandra said, the system adapts. So you can't really give it a lot of time. And, there's an immense amount of pushback on any kind of innovation in this kind of system. So models can help you kind of simulate reality and then poke at it and see what happens. And then, of course, very cautiously translate those results. So love the paper, and thank you very much for allowing me to speak on this.
Thank you so much, Siddarth, for summarizing it really quickly. So we'll move on to the audience questions. So I can see, 1 second. Shaker B, he has been asking about the problem of adjournment. So I think, as we have discussed many times, why do we still see a lot of adjournment? Is the reason why the court hasn't corrected on this particular aspect? Because the Tariq, that I can see that question being asked again and again. So Professor Aparna or Siddarth or anyone, or Bakshi, Professor Bakshi, if you can just answer on that.
I think Aparna would be the right person.
I'm happy to take a stab at it. I think this is what I was referencing in terms of talking about a particular legal and litigation culture where courts and lawyers are very happy to let matters slide. There are many, many reasons for this. There's some reasons to do with political economy. Lawyers are paid per appearance. They're not paid per case. And so the more number of hearings that you have, it might be better for them. There are games that lawyers play and litigants play. We assume that delay is a bad thing, and it's a bad thing for the system overall, but at least for one party, it's a good thing, as that's the party that's approached the court in the first place, and that's the party that's going to be driving the case in the appellate system. And so very often for the appealing party, or even, it might be for the other side as well, but for at least one party, delaying decision is actually a good thing. That's something that they're actually sort of, strategizing around. So which is where, for example, adjournment is one part of the problem. And I would think that adjournment is undercounted only because these are cases where the judge is actually, saying adjourned, right? But even in regular hearings, we know this. We know the games that lawyers play. They will say at the end of the hearing, okay, why don't give me some time? I will produce this particular document. That is not counted as adjourned. You've had a regular hearing and the court says, okay, list after 4 weeks to produce this one simple piece of document. Then at the next hearing, the lawyer will come and say, it's taking a little bit of time. So then the judge will adjourn it, so on and so forth. And the thing with all of this is that there is no, and I think this goes back to Professor Bakshi's sort of initial comments. that the particularly for the cream of the crop in the Supreme Court, and I don't even mean grand advocates, right? I mean people who have robust practices in the Supreme Court. For all of them, they're incredibly busy people. They have much more work than they can really deliver on. There is no check in place to say that, you cannot be double booked. Because each court is setting its own schedule. It is once a case is listed before a particular bench, that bench has no visibility on what this lawyer is doing in any other court in the Supreme Court. Of course, nothing in the Delhi High Court or any of the tribunals or any other place, right? So it's very easy for lawyers to get away with saying that they're double booked or there's something or the other. And even other lawyers will generally sort of allow for some kind of leeway, understanding that tomorrow when they are on the receiving end, they would want their other colleagues to allow them some leeway. So this is a culture problem. And to my mind, it has to be addressed as a culture sort of issue, because if it is not, then my worry is that to bring down adjournments, judges are likely to say, or lawyers are likely to say, okay, I'm not asking for an adjournment. You heard this matter. In order to present my case better so that I get actual access to justice, you have to give me another date to be able to produce this new thing that you are now asking me for. So, I mean, just to say that these are the courtcraft and strategies that are used and are very normalized in the Indian system.
Thank you, Professor. We have a question from Om. He had raised his hand quite a long time back. So, Om, if you could unmute yourself, you can go ahead and ask the question.
Hi. Yeah, thanks. Thanks for the fascinating. So I think Professor Aparna and Professor Ramana have actually addressed what they talked about, a lot of systems issue. When we outside the flow, what all is there in the queue? The things are in the queue, but what else is outside the queue? So one of the things when you look at everything outside the queue, the question is what are the sources and sinks? Like many point in the presentation, the issue came, if we have one more bench, more cases will come. But what happened? Why are those cases not coming in the current system? So, what are our assumptions with respect to total number of cases that are going to be filed, regardless of the number of benches? Because people have that need. There is some feedback with respect to delay. Then the High Court bench again. What is the total amount of judges' time? It was said that if the judge does, when they become free, they do something else important, but it affects the congestion. But when is that other important things done? So if the judge was not free, then that other important thing still needs to be done. Does it take away from judge's time on some other day? So all of this, I think, fall under the metric of conservation law in a systems framework. What are your assumptions about the variable bound, their sources, sinks, and the flow rates? And whereas here, it appears to me, I may be wrong, although many of those assumptions are being violated. So that is really the crux of them. And of course, all other systemic issues, what kind of feedback those things generated, the amount of time a judge spends hearing, is it a function of the queue they have? If they were free, will they spend more time? If there are a lot of pending cases, will they spend less time? So of course, the model assumes some certain distribution, but those feedbacks are the other systems issue that I think are being asked. Thanks.
Maybe it's for me, and I could attempt to answer some of those. One is the arrivals of cases is whatever it was in the data. So we look at raw arrival of cases to the Supreme Court. When we were discussing the issue of the impact of adding a judge, that was conditional on the understanding that stage 2 is congested. So in that sense, the arrivals to stage 2 or the post-admission stage of the queue is controlled by the judges, right? So let's say you appointed another panel of judges. So from the strength of the Supreme Court went up from 28 to 30. Then they would be able to handle more of the backlogs of fresh matters. And because they can now handle more, because Monday, Fridays are devoted to the stage 1 or pre-admission cases, right? So because now they can handle more of those, more are being admitted. So the arrival rate to stage 2 goes up. So it's not that the arrival of cases to the Supreme Court went up. We're only looking at the arrival to the post-admission queue in this discussion, in this particular discussion. With regard to and the time of the judges, right? So we're focused on the amount of time that they're spending hearing cases. And one of the constraints over there is that you have to schedule the cases in advance. You can't do it at the last moment. Oh, now the judge is free. Can we take another case from the queue and schedule it? It has to be done a few days in advance. So now what happens is that, let's say we schedule 60 cases and it was a good day. We got through them very quickly, or many of them got adjourned. And as you've been pointing out, adjournments take less time, few seconds sometimes. And we got done before it was 4:30 p.m. Now, the remainder of the time, I don't have a new case available. Now, I could make myself useful and start working on other things, but not hearings. That's what we wanted to highlight. Now, if I did not have that spare time, when would I have done that paperwork? I don't know. The judges work a whole lot, right? They do a lot of after hours work as well. So maybe that night they watched a bit of television because they did some of the work during the court hours. I don't know. But that's a good question, right? But where would that work get captured if you hadn't finished cases earlier that day? Probably they work a lot after hours. And that's what my impression. They work really hard after hours. So I've been to their residents as well and seen how in their private offices they're working all through the evening with their staff and preparing the cases and writing briefs, etc. So hopefully I shed some light on the questions. I don't know if I captured everything there.
Yeah, I think Om has a question, but Om, I think we are short on time. So I'll just go with what Renu had asked on the question and answer section. So she asked if the study examines the government as the congestion cause, biggest litigator, and what is the dismissal rate on the SLPs filed by the government. I mean, it's not there, I mean, in the study, but have you thought about it, Professor? I mean, the government being the biggest litigator, I mean, I think more than 50% of the cases being that.
Yeah, we didn't focus on that, but that was stated in the literature, so I'm aware that that's the case. And Aparna was mentioning that also. If you are willing to revisit these kinds of questions, perhaps there are bigger wins against congestion. My own sense was that these have been debated ad nauseum. We're not changing anything in this respect, asking the government to litigate less or changing the scope or the mandate of the Supreme Court to focus on constitutional matters. So we took those kinds of things as given. But that is not to say these cannot move the needle. I think if you were to make the government less litigious, sure, congestion would go down and the judicial structure would look very different. Those are great points. I think I would leave it to legal scholars to sort that out. My perspective is more operational, right? More logistics driven. So I keep the legal aspects of judicial decision making fixed, and I visit things from the operational angle. Not to say one perspective is more important. Think of it as a complementary perspective, that if we combine forces, we'll be more powerful than one entity by itself.
Unfortunately, we have.
If I may just say
Yeah.
one thing, just in addition, you're absolutely right. The government is by far the biggest the litigant. And I have looked at data in my work on different case types, and the government really loses big time. So in tax matters, revenue matters is one of those places where the government loses more often than it wins. Apparently, again, this is a political economy question. There are great incentives for people in the revenue department to actually file the appeal than not file the appeal. They are more likely to get hauled up if they don't file an appeal than if they do file an appeal, even if it's a weak case. And so the government is on some of these matters, particularly in revenue matters. I think our data showed that about 70% of the cases, appeals that the government files, it loses in the Supreme Court. So that's a huge number. That's one of the biggest, anyway, bucket of sort of civil cases that go up before the Supreme Court in any case.
Thank you, Professor. When we have reached the time now, it's past 8. I had several questions actually listed down. One question being to Professor that if you have, being a concerned resident of Bangalore, have you studied the congestion of road traffic in Bangalore? But that's beyond the scope of the study. So, on behalf of DAKSH, I would like to thank Professor Nitin Bakshi for initiating a data-driven conversation on congestion in the Indian judiciary. Sir, thank you for being very flexible. We were able to organize this whole webinar at a very short period of notice. And thanks to Professor Aparna and Siddarth also, because you're also quite flexible with the timings and the format. Thank you, Professor Aparna. You gave a rich and in-depth input regarding the paper. When your experience being in the field, that is the quote, you were able to give a worm's eye view to what Professor Nitin gave. That's a bird's eye view, and that's very important in any academic research. And a small trivia. India went on to go to the Indian hockey team, which I mentioned. They went to the semifinals. They lost to Germany, and the German team was coached by a lawyer, Andre Henning. And so it's quite hard to defeat a lawyer in any field here. And thank you, Siddarth, for quickly building the bridge between different strands of theory, models, and knowledge that were discussed in the whole webinar today. I'm sorry that you got a very short time, but you were able to really summarize it very quickly. And I would like to thank my colleagues who were able to guide me in any doubts that were in the paper. I'm not a lawyer. I'm a data analyst. I'm from a public policy background, so I was able to understand the thing, and I was able to understand the statistical part, but not the law part that well. So thank you so much. Thanks to Harshita, especially for being very patient in getting it organized. Thank you to everyone for attending the important discussion. I know 1.5 hours of intellectual debate is really, really hard, but you were able to stay throughout. And hoping to see you all again in the future or webinars organized by DAKSH. And hoping to engage with all of you, Professor Nitin, Professor Aparna, and Siddarth, and hoping to work with you on this topic in the future.
Can I take just a moment to thank the discussants? Yes. And also, I don't think I did full justice to their really comprehensive questions. So maybe I could continue this conversation with them offline, and especially both sets of discussants have given me some food for thought, because ultimately this is not just another paper for me. I wanted to have some impact. So what you're highlighting is from a practitioner standpoint, what are some of the concerns? And I just have to get to the bottom of those. So if you're willing to engage with me offline, I'd really appreciate that. And thank you so much for your comments.
Absolutely. Thank you. Thank you so much. Really enjoyed the paper. Thanks.
Thank you. Appreciate it.
Thank you so much.
Thank you, Rohit.
Thank you.